So good morning, everybody. Thank you for being on this call with us today. It's on the Virginia Employment Law Update. Our guest speaker today is Betsy Davis, who's a partner at Whiteford Taylor Preston. They are one of our Gold Elite sponsors, and we're so happy that they help us and have always provide us great information when we ask them. So Betsy, I'll just turn it over to you.
Okay, great. So again, my name is Betsy Davis. I'm here in Richmond, Virginia at our Whiteford office. We have other Virginia offices in Northern Virginia, Roanoke, and down in the Virginia Beach area. It's great to be with you all today. We have done this before and a lot has happened since we last met. So in July of 2020, the legislature entered into a number of new updated laws that are fairly employee centered. And so we'll talk about that today. And they did a little bit more the next year in July of 2021. So my goal is to update you all about new laws so that you can go back and look at your organizations, look at your policies, look at your practices, and make sure that you're up to date. Paula warns me you're not a big question asking group. I'm happy to answer any questions, and I will send this PowerPoint to Paula. Again, there's so much to go through today. I'm not sure we're going to get through it all in an hour, but I will do my best. Don't let that stop you from asking questions. But all the information will be available to you. So also, please feel free to reach out to Whiteford Taylor or to me, and we will answer any questions that you have. So let's jump right in. And there we go. So again, I said there were a number of new laws. I have selected the new laws that I think impact your industry. Most specifically, I work often with continuing care, retirement communities, and folks providing in-home health care. So these are the statutes that I think we should focus on. There are other statutes out there that you should also be aware of, and we'll hit as many as we can today. So first, the Virginia Human Rights Act has been amended by the Virginia Values Act. So we'll talk about that today. That's a big change in Virginia. In addition, the Virginia Wage Payment Act has been amended, the Virginia Overtime Wage Act. Everybody wants to know about what can employers do about cannabis in Virginia. So we'll talk about that. Will I have the right answers for you? I don't know, but I'll give you some suggestions. The Virginia Fraud and Abuse Whistleblowing Protection Act. We'll talk about that one. There's a new statute that relates to misclassification of workers. So whether you've classified your workers as an employee or independent contractor, that's a new statute in Virginia. I want to make sure you're aware of that. And there's a new statute relating to non-competes. So if you use non-competes, particularly for your executive level employees, you might not change your practice with respect to those folks, but a lower level employee, this particular change will impact them. So let's jump right in. So the Virginia Human Rights Act, as I said, it has been amended by the Virginia Values Act. When most of you probably have more than 15 or more than 20 employees, so you are accustomed to operating under the federal statutes, Title VII, the Americans with Disabilities Act, the Age Discrimination in Employment Act. The Virginia Human Rights Act has traditionally fit in the 5 to 15 employee category. Well, that has all changed. So I want to make sure you're updated on those things. In addition to that change in what type of employer this statute applies to, the Virginia Human Rights Act in the past has only applied in situations where the employee has been fired. That's not the case anymore. In the past, if the employee was fired because of his or her race, color, religion, national origin, sex, pregnancy, childbirth, or age, and again, limited to that 5 to 15 employees, we look to this statute. And so employees and plaintiffs' counsel were looking and saying, do I go under the Virginia Human Rights Act, and do I exhaust my administrative remedies with the Virginia State Agency and then go to state court? Or do I look at the federal statutes that we talked about, Title VII, ADA, ADEA, and do I look at the EEOC and federal court? The options have changed now. So effective July 1st, 2020, either the plaintiffs and the plaintiffs' lawyers can either look at the Virginia Human Rights Act or Title VII. So now the Virginia Human Rights Act is also going to apply to those larger employers, the employers that have 15 or more. And it's also going to extend beyond just termination cases. So the prohibitions include, like Title VII, like the ADA, like the ADEA. It's also going to include refusal to hire. It's going to include discriminatory treatment at the office. So segregation in particular classes based on your protected class, or refusal of opportunities, promotion, demotion, use of their protected class as a motivating factor in an employment practice. So if the employee is going to be disciplined and says they're disciplined because of a protected class, that would all apply under the Virginia Human Rights Act now. So it's really expanded what the state law is going to cover. In addition, the state law has expanded its protected classes. And so we'll go through those. Some of those are evolving already under the federal law, but this state law has expanded. So now sexual orientation and gender identity are included as protected classes under the Virginia statute. And so sexual orientation can mean whether someone is perceived to be heterosexual, bisexual, or homosexual. So any sexual orientation will be covered. It's not one or the other. And then also gender identity, I think, is a definition that is often misunderstood. So gender identity means gender-related identity, appearance, gender-related characteristics of an individual without regard to the sex that the individual was assigned at birth. So if someone is perceived to be a female but identifies as a male, that would be an example. And there are more protected classes that have been added under the Virginia Human Rights Act by the Virginia Values Act. Veteran status has been added. Hair is a new protected class, and it has fit in under this idea of because of race. So when someone says that they have been treated differently because they wear braids or they have locks or they have twists, that would be a protected class. So if you hear those words in complaints or in response to performance issues or any other HR process, you want to make sure you take note and ensure that you're following your handbook processes. Lactation has also been added as a protected class, and it's added under this idea of sex or gender. And so lactation is defined as a condition resulting in feeding of a child directly from the breast or expressing breast milk. And I think a lot of us are already dealing with those issues under Title VII, but this has just added it to the state statute. So one of the most significant points about if I'm already subject to the federal statute, why do I care that now I'm subject to the state statute? Damages are the reason that employers that have 15 or more particularly care about being subject to this state statute now. So under the Virginia Human Rights Act, a change is employers that have 15 or more employees are now subject to unlimited compensatory damages. Compensatory damages under Title VII, for example, are limited to a cap based on the size of the organization. So plaintiffs' lawyers and plaintiffs who have good plaintiffs' lawyers are really looking at the Virginia Values Act and the Human Rights Act as an opportunity to increase what they're alleging they're owed in these cases. So they can bring the Title VII case they've already been bringing in federal court, and then they can add the Virginia Human Rights Act amended by the Virginia Values Act as supplemental to that claim and try to increase their damages. So that's really why we care about these new changes to the state statute. It's giving the plaintiffs ability to assert a larger addendum or more damages. And then in addition, there are punitive damages, there are attorney's fees, and there's an ability to get an injunction. And those are things that are available under the current federal statutes. So there's been a focus in the Virginia Human Rights Act on employees experiencing pregnancy, childbirth, or related conditions. And these are things generally that you probably, if you're subject to Title VII, are already dealing with under discrimination on the basis of sex. The Virginia Human Rights Act makes a specific focus on these categories and gives us some more information about how Virginia is expected to handle it. So the statute specifically requires that employers who are subject to it provide a reasonable accommodation, unless doing so would be an undue hardship. And we're used to that standard under the Title VII. In the Human Rights Act, there is a specific definition of reasonable accommodation. And I know you all have been through this process. And again, I can't stress enough how important kind of process is in dealing with claims for reasonable accommodation and going through that interactive process and then documenting it. So when you have someone, and in this case, we're focused really on the pregnancy issue. When you have someone that says, I need an accommodation because I'm pregnant, it's important that you go through the interactive process and it's important that you document it. The statute tells us good examples of what a reasonable accommodation might be, and you all are probably used to doing this already. But the statute includes in their definition of reasonable accommodation, more frequent or longer bathroom breaks, the ability to take a break to express breast milk, access to a private location. So we often have battles about there's a women's bathroom, you can do it there. That's not acceptable either under the Virginia Human Rights Act or under Title VII. So there needs to be a private location in order to handle these obligations that a mother may have. Acquisition or modification of equipment, temporary transfer to a less strenuous, hazardous position. And I just want to point out, and you all, I saw a lot of HR folks on the list are probably fully aware of these issues. Transfer is really one of the last accommodations we're going to consider. So when you go through every other option and there's nothing else that you can offer or that the employee requests in order for the employee to be able to perform the duties of their job, you can look at transfer. I wouldn't suggest that as a first position. I would hear what the employee has to say, determine whether or not that is something that can reasonably be accommodated, and then respond with another option. It's not the employer's obligation to provide the accommodation requested. It's the employer's obligation to provide a reasonable accommodation. So if the employer has an accommodation that meets the needs, but is different than what the employee requests, the employer can require that accommodation. I just stress that transfer is not the first option. It should really be one of the last resorts. Assistance with manual labor or job restructuring. We often have pregnant employees that have a lifting restriction. If the employee's essential function of their job is to lift, you don't have to hire somebody else to lift for them. If once a week they have to lift a heavy box, requiring somebody else to do that would be a reasonable accommodation. Modified work schedule or light duty assignments would be something to consider. And then obviously leave to recover from childbirth. So you all may have maternity leave policies, you may have FMLA. And if you don't have any of those things, you might look at whether leave is an accommodation under the Virginia Human Rights Act. So undue hardship. Undue hardship, I have employers that always want to point to undue hardship. The employer has the burden of proving an undue hardship. So that would be the last in my analysis of where we want to rely to say we're not providing an accommodation. But the Virginia Human Rights Act has now provided us some structure that says what we can rely on. So the act says that we can call an undue hardship something that is a hardship on the conduct of the employer's business, the employer's operation, or the composition and structure of the employer's workforce. So an example of that might be where you have only one employee that does a very essential function of the business. And having that employee out of the office for a particular period of time would stop the function of the business. That might be an undue hardship. Other factors to think about with respect to undue hardship would be the size of the facility. Again, it goes to the example we just talked about. If you've got 10 people that do the same job and one person has to be out, that might be something you can accommodate. It might not create an undue hardship, but if you have a single individual that has that expertise, it might be more of an undue hardship. And then the nature and cost of the accommodation can be considered. So what we just talked about were the changes in 2020. The next year, the General Assembly made some additional edits to the Virginia Human Rights Act in 2021, effective in July of that year. One of the things that the General Assembly did is it added disability to the list of protected classes under the Virginia Human Rights Act. And again, this applies to employers with more than 5 employees. The disability provisions of the Virginia Human Rights Act are going to be very similar to the ADA. So if you were subject to the ADA before, there aren't a lot of changes, except the fact that it's going to include smaller employers. But there is, again, a significant change with respect to damages. So plaintiffs' lawyers are going to want to claim both issues under the ADA and issues under the Virginia Human Rights Act, because they want to at least negotiate under the higher damages under the Virginia Human Rights Act. So under the ADA, there's a cap on damages. Under the Virginia Human Rights Act, there's not a cap on damages. So if the employee has truly suffered a significant damage, it doesn't matter how large the employer is, and there isn't a cap. So that's something that the employees are really going to push going forward. And then, just like the ADA, there are punitive damages that are available, attorney's fees that are available, injunctive relief that's available. So now, employers who are subject to the Virginia Human Rights Act and the new disability protected class have to provide a reasonable accommodation if they employ more than 5. So in the past, again, those employers that had 5 to 15 didn't have that obligation. So now they have an obligation, and that's a change from the ADA. One thing that everybody should be thinking about is the ADA doesn't require a posting or a notice requirement, but the Virginia Human Rights Act does. So all employers that are covered, so 5 or more, you're covered, have to include language that discusses the right to a reasonable accommodation based on a disability in their employee handbook. So it's an obligation like under the FMLA, where you have your FMLA notice in your handbook. You now have to have that accommodation notice for disability in your handbook. And that's something other states have done for a long time. So if you operate in many states, you may already have that in your handbook. If you operate only in Virginia, you probably don't and might need to amend your handbook and add that. There's also a requirement that you post in a conspicuous place, just where you put your, FLSA posting or your wage and hour posting, the requirement that the employer provide reasonable accommodation. And if anybody needs that standard poster, I can send that out as well. And then we have to provide notice of employees' rights to accommodation upon hire. So within 10 days of hire, employees need to receive that notice. And that could be in the handbook, if you all have a handbook that has that provision. So the change really is the reasonable accommodation process for smaller employers. So now, before we talked about under the Virginia Human Rights Act, it was only an issue with respect to termination. If you terminated an employee, you couldn't do it based on these protected classes. Now, employers are prohibited from taking an adverse action against an employee who requests or uses a reasonable accommodation. They're prevented from denying employment or promotion to a qualified applicant because they've applied for an accommodation or taken an accommodation. You can't retaliate against an employee who requires leave as a reasonable accommodation. And you have to engage in that good faith interactive process to discuss the accommodation. And so these are things that if you have more than 15 employees, you've been doing all along under the ADA. But if you're in that new category, 5 to 15, these are new strategies that you'll have to train on and implement. So let's give a little summary about what we need to do with respect to the Virginia Human Rights Act. First thing on your list should be go back, look at your handbook, look at your policies, and make sure they're updated for these new requirements. Second thing is to really focus on pregnancy, lactation, LGBTQ, and military protections. Many policies that employers have with respect to grooming or attendance and break times need to be updated with respect to these issues that are new in the Virginia Human Rights Act. And then we really need to train, and educate. So we want to educate our executives, HR folks, and managers about the interactive process. Most cases I have where my employer clients might have an issue with respect to accommodation under any of these statutes relates to the fact that maybe they had discussions, but they didn't document it. So more conversation and full documentation about what you talked about, what they requested, did they request it in writing? Did you respond in a reasonable amount of time? And did you offer something that was reasonable? Documenting all of that, including it in your employee file, is really the strategy to take in these kinds of cases. And then, nobody likes to do performance reviews. Everybody wants to just give everybody a pass and move on. But if you have a discrimination issue, we always look back at verbal performance assessments, written performance assessments, and what documentation is in the file. So making sure that anybody who's responsible for that, executives, HR, managers, are doing that effectively and honestly is always important. And that's before the Virginia Human Rights Act that relates to any discrimination claim. And then finally, it's really important for our executives, our human resource folks, and our managers to recognize when a complaint has been made. And when they hear that, to make sure they get with HR about that, because HR, I think, is best equipped to deal with it. So instead of, passing it off as a complaint, so-and-so is always complaining about something, it's important that folks are listened to and that individuals, particularly individuals that are identified in your handbook as reporting directives, that they react and act upon those complaints, even if it's a complaint that's unfounded. It's important to be able to demonstrate that the complaint was taken, that the complaint was reviewed, and the complaint was addressed. So it's important to identify that for the folks that you work with. Okay, really briefly on the Virginia Minimum Wage Act, I think everybody's probably up to date on this one. Starting January 2022, minimum wage goes up. If you've got minimum wage workers, whether they are housekeeping, in the dining facility, CNAs, we need to make sure that they're being paid the appropriate minimum wage, and this wage is going to increase annually until there's a change in the law. And we know that there's been kind of a swing in politics in Virginia, so we should keep an eye on this. But as of January 1st, 2020, minimum wage goes up from $7.50 to $11 an hour. We need to make sure we're all complying with that. And then we're going to move on to the Virginia Wage Payment Act. So there are several statutes that we're going to talk about today that impact how employees are paid. The federal law that deals with how employees are paid is the Fair Labor Standards Act. And so up until July 1, 2020, the Virginia Wage Payment Act coincided with the Fair Labor Standards Act. So we didn't need to focus on anything but the federal law. Now, effective July 1, 2020, there are some changes to the Virginia Wage Payment Act that have obligations for employers that exceed what the Fair Labor Standards Act requires. So now we need to pay attention to the Virginia Wage Payment Act, and there are a couple others we're going to talk about. So importantly, under the statute, again, the statute provides for what we call a private right of action, which means that it's not an administrative procedure that goes to the Department of Labor and Industry in Virginia. It is a claim that the employee may have that the employee could bring in court. So we want to focus on what our obligations are here and make sure we comply with them. So the employee can sue individually or the employee can sue collectively. And that's similar to the FLSA, the Fair Labor Standards Act. There is a 3-year statute of limitations under the Virginia Wage Payment Act. That's a little bit different than the Fair Labor Standards Act. Under that statute, employees can go back 2 years unless the alleged violation is willful, and then they can go back 3 years. Here, the employee goes back 3 years. That's a significant change from the perspective of an employer who might have to pay damages for a mistake in how they pay a large category of employees. Even if it's a small differential, when there are a large number of employees and you have to go back 2 years and then you add a year to that, it can really add up. And these cases really do get expensive. And then the other change that's different than the Fair Labor Standards Act is that statute of limitation is told if the Department of Labor and Industry is investigating. So many times, if there's been an issue with respect to one of the requirements under the FLSA or the Virginia Wage Payment Act, an employer might correct the issue going forward and wait for that time period to tick off, relying on the statute of limitations. But here, if the Department of Labor and Industry is investigating, that time period is going to stop. So you're going to be subject to all of those claims without them expiring. Again, damages is really the focus for this employee-focused General Assembly that we've had for the last 2 years. Damages under the Virginia Wage Payment Act include wages owed, which are the same as the Fair Labor Standards Act, the federal law, liquidated damages, which are also available under the federal law, prejudgment interest, attorney's fees and cost, again, available under the federal law, but triple wages for knowing violations. That's a change. And again, it provides a greater deterrent and larger damages under this Virginia statute. So we are expecting employees and their attorneys to really be focusing on the Virginia statute going forward. There are also criminal sanctions available. That's also available under the Fair Labor Standards Act and really limited to cases where the Department of Labor and Industry have come out and said, this practice violates the particular statute. You have to correct it. You agree to correct it. They come out to re-audit and you fail to correct it. So those are available both under the federal and the state law. So a new provision under the Virginia Wage Payment Act is this retaliation provision for misclassification. So the statute now protects employees who have either initiated a lawsuit or testified in a proceeding that either their wages have been improperly deducted or they haven't been classified correctly. So they've been classified as exempt when really they were non-exempt. And so that really goes to minimum wage and overtime. The statute doesn't specifically express a protection for internal complaints. So where the employee says, I think I should be paid overtime, I think I should be non-exempt, and they report that to the controller of the organization, and the controller looks at it and says, no, I'm pretty sure you're exempt, so I'm going to continue paying you the way I've been paying you. If it's determined that they truly are not classified correctly, this statute does not clearly protect that. And we're watching that. We'll see how the courts rule on that. But what it's really focused on protecting is the employee that sues the employer and says, I should have been non-exempt and I am entitled to a lot of overtime and I want you to pay me that. And then the employer takes some adverse action. It's hard for an employer to continue to work with an employee who's involved in federal or state litigation against the employer. But this statute protects the employee. So if the employee remains employed, files that lawsuit, and then is demoted, is terminated, is disciplined, the employee may have an additional claim under the statute. And the remedies that the employee would be entitled to under the statute, if they're able to demonstrate that truly they were retaliated against, would be reinstatement. So the employee that was terminated would have to be rehired, which is a very difficult remedy to comply with. Lost wages. So if they were demoted and they took a 25% pay cut, they'd be entitled to that 25% pay again, and then liquidated damages with respect to their lost pay. So this is an interesting provision that I'm not sure everybody is aware of. The wage transparency provision of the Virginia Wage Payment Act prohibits employers from terminating or retaliating or taking any kind of disciplinary action against an employee who discloses their compensation to another employee or communicates with another employee about compensation. I don't see it regularly, but I do see circumstances where employers will include in their handbook a provision that says compensation is confidential and you're not entitled to discuss that. Other than the Virginia law, there's a complete other issue about whether that particular provision would violate the National Labor Relations Act. So the statute protects what they call concerted protected activities, allowing employees to get together to talk about their wages in order to advocate for higher wages. So generally employers are taking these out of their policies and handbooks for that reason. If it's still in your handbook and you're working in Virginia, it needs to come out now. So this statute prohibits it. There are civil penalties not to exceed $100 per violation, whether the Department of Labor and Industry will determine that a handbook violates each employee's right. That number could add up. So what do we need to do with respect to the Virginia Wage Payment Act? Again, review your classifications. Is everyone properly classified as exempt versus non-exempt? And that's something that I recommend employers do every year, every 2 years anyway. What I recommend employers do is that when they have their annual evaluations, they review with the employee their job description and ask the employee, do you agree that these are the duties that you are required to perform and are actually performing, and have them sign their job description annually? And if there needs to be an update to go ahead and update that. With respect to classification, when I have cases, before always under the Fair Labor Standards Act, now I expect we'll have it under the Virginia Wage Payment Act as well. What I hear from employees is, that's what my job description says, but that's not what I did every day. And, employees always like to bolster the work that they do while they're working. But if they have an opportunity to sue the employer and demonstrate that they're entitled to overtime, particularly when they were designated as exempt and not keeping their time, they will say, although that says I was directing the work of 2 employees, they didn't report to me, they reported to my boss. Although the job description says I was in charge of ordering and strategy, I really just did data entry. And so going through the process of having the employee during their review period, review their job description and affirm it annually is an opportunity to defend against that. And it also makes sure that they're doing the work that they do. Some employees will get a job description and never refer to it again. Another thing that employers should do to ensure compliance with the Virginia Wage Payment Act is to review their handbook and make sure that they're eliminating that prohibition against discussing compensation. And then I always recommend that a handbook contains a clear compensation compliance process. Couple ways this can help employers. There is a safe harbor provision under the Fair Labor Standards Act. So if employees' salaries, when they're exempt, are improperly deducted, that could convert the exempt employee to a non-exempt employee. We don't want that to happen. One mistake like that could convert the entire class, which could be expensive. But if you have a safe harbor provision, a provision in your handbook that says, if you feel as though your compensation has been deducted or not paid correctly, notify, whether it's the CEO, whether it's human resources or the COO, and then investigate that. If there is a mistake and you correct it, it won't impact the whole category of employee. So I always recommend that kind of safe harbor or clear compensation compliance provision in the handbook. Okay, so let's talk about the Virginia Overtime Wage Act. This is similar to what we just talked about from the perspective of how it interacts with the Fair Labor Standards Act, that federal statute that impacts how employees are paid. So again, the Fair Labor Standards Act, we used to rely on 100% because all of the Virginia statutes that related to the question just incorporated what the Fair Labor Standards Act required. Now there's a little bit of a difference. So we have to both look at the Fair Labor Standards Act and comply with that, and also look at the Virginia Overtime Wage Act. So this statute, actually, I think it became effective July 1, 2020. I'll have to go back and check that. It does create some new wage and hour requirements. And one of the biggest and most significant impacts deals with calculating what's called the regular rate of pay. So anybody on the call that deals with HR or accounting will know that we look at the regular rate of pay when we determine how to pay overtime for hourly employees. Again, in the past, the Virginia statute just tracked what the Fair Labor Standards Act said. Now, under the Virginia Overtime Wage Act, if you have an hourly employee, the calculation is the same. You're not going to change your process at all. But if you have a non-exempt employee that you pay on a salary basis, the analysis is going to change and it's going to cost you more money. So if you have that situation where you have the salaried non-exempt employee, so they're entitled to overtime and they must get paid more than minimum wage. But if they work fewer than 40 hours in a work week, they still get their full salary. That's the arrangement some choose with employees, and it works fine for them. Now, when we calculate overtime, we used to calculate it under the Fair Labor Standards Act as agreeing on how many hours they were going to work, whether it was 50, whether it was 60, and what salary we were going to pay them, and then divide by the number of hours they worked. Under the Virginia Overtime Wage Act, we're going to divide by 40, even if they work 50 hours. So what that's going to do is it's going to increase their regular rate of pay. With the increased regular rate of pay, if they're working 10 hours of overtime, we're going to have to pay them time and a half on that larger number. So it's going to be more expensive. And we want to make sure we don't miss that nuance of the statute. So in addition, for some folks, we were working on fluctuating work week methods. Under this new statute, it really takes that away in Virginia's wage and hour law. So we don't have the opportunity to do that. It doesn't calculate correctly. So what this means for employers is it really does increase the damage. So the regular rate of pay increases, the overtime will increase. And so we really need to make sure that we get this right. And I think, it's not unheard of, but it's not as common as either having a salaried exempt employee or having an hourly non-exempt employee. A middle ground, a non-exempt employee, would be that salaried non-exempt employee. And so in that case, you need to go back and make sure you're calculating overtime correctly. So this Overtime Wage Act similar to the other statute impacting wages in Virginia, it does provide these new tools for employees and for employment lawyer or plaintiff lawyers. So instead of 2 years again, under the Fair Labor Standards Act, we're going to have a 3-year statute of limitations. So if there is an error, they're going to be able to go back for a longer period of time and calculate damage. In addition, liquidated damages, which are generally under this statute and under the Fair Labor Standards Act, it's 2 times the wages they weren't paid. We saw under the earlier provision that there's a requirement for treble damages, but here it's 2 times. Under the Fair Labor Standards Act, it has to be a intentional violation. Under this Virginia Overtime Wage Act, doesn't have to be intentional. So there's not that additional evidence that the employee would have to show. So in every case, they're going to ask for double damages if there's been an error. And then here, there's the opportunity for treble damages if you've got that knowing violation. So if you knew you were supposed to pay on the higher regular rate of pay and you didn't, then the damages will be tripled. If you knew you should have paid overtime, but you didn't, the damages will be tripled. So employer tips under the Virginia Overtime Wage Act, go back and review your policies carefully, make sure you've made the edits that are required under the statute. And then when you're conducting wage and hour audits, make sure that employees are properly classified, make sure they're paid correctly, and make sure you've calculated overtime correctly. And this is probably something you do annually or every other year, just under the Fair Labor Standards Act. So just make sure you're incorporating these new Virginia statutes when you do that analysis. Okay, let's talk about marijuana in the workplace. Everybody's got questions about this. The answers are unclear, but let's give you what we know. So everybody probably has heard on the news and is aware, their employees probably told them that recreational marijuana is legal in Virginia now. So if you're 21 or older, you're permitted to possess small amounts of marijuana and cultivate 4 plants each. There's also a statute that allows for protection of employees who use cannabis oil and using it at work. So if they have a valid certification from a practitioner that will eliminate certain medical symptoms, then they're entitled to use cannabis oil. There are some exceptions that I think it's important for the employer to know about. So the employer can still take an adverse action. So that means you can discipline, you can put on leave, you can terminate an employee if there is a known impairment at work caused by the use of the cannabis oil. Also, the employer isn't required to be in violation of a federal law if enforcing this state law would require that. So that happens most often when an employer has a federal contract, and in that federal contract, the employer must verify that they have a drug-free workplace. So that's the most common example of that. And then there are some prohibitions about whether or not you can hire an employee who has a positive test. And so there's an exception in the statute for any defense industrial-based sector employer or prospective employer if they test within the numbers you see on the screen there. Those folks don't have to hire someone with a test that fits these numbers. So we always talk about what applies, this state law or this federal law, and how do employers, deal with the seemingly very different and contradictory laws in the workplace. So the Federal Controlled Substances Act of 1970 classifies marijuana as a prohibited drug. The Federal Drug-Free Workplace Act requires federal contractors to certify that they have a drug-free workplace. And then we have folks that have drivers, and the US Department of Transportation asserts that state cannabis laws don't modify its drug-related regulations. So those two things are in direct contradiction. So how do we resolve those? Can the employer prohibit marijuana at the workplace? Yes, you can. And let's talk about how practically that happens. So Virginia's new marijuana laws don't stop the employer from being able to say, you cannot use marijuana in the workplace. You cannot have marijuana in the workplace. The federal law still considers marijuana to be an illegal drug. So you can still drug test. You can still say marijuana is not permitted in the workplace. There's a practical issue here, and it has to do with what many employers are deciding to do with respect to what drugs are we testing for, what drugs are we prohibiting, what does our, substance abuse policy look like. With respect to alcohol, for example, alcohol is legal for folks of a certain age, but you can't be under the influence of alcohol at work. The same principle applies with respect to marijuana. You can't be under the influence of marijuana at work. It creates an unsafe workplace. It creates an unproductive workplace. The problem is when you test for alcohol, the test demonstrates the current impact of alcohol, and then it wears off. And then, within X amount of hours, you wouldn't find the presence of alcohol, or the presence would be so diluted, it wouldn't be significant. Marijuana is different. If you ingest marijuana, you will test positive for the next 30 days. And so the employee wants to say, I legally engaged in smoking marijuana on the weekend, and now you're testing me, I'm not impaired at work. So my recommendation to employers have taken really two strategies with respect to marijuana that I have dealt with. Some have said, frankly, I can't hire anybody if I pre-screen for marijuana. Nobody will pass this test. And so I've decided to take it off my list. You all can choose to do that or not choose to do that. If you choose to test for marijuana and you hire someone and then conduct random drug tests and they test positive, an additional step I would recommend that you take is, or if they're tested because of an accident, or if they're tested because of reasonable suspicion, I would train whomever is handling that to do also a visual analysis of what's going on. So are there other signs that the individual is currently under the influence? And those would be, are their eyes glassy? Are their eyes red? Are they slurring their speech? Are they acting unusually? Are they unable? Are they uncoordinated? Is their mood changed? So if you have a positive test and those additional factors, you'd be able to demonstrate that the individual had not only tested positive, but was also currently under the influence. And currently under the influence is certainly prohibited. So marijuana is a difficult issue. Those are the strategies that many of my clients have used going forward. One thing to remember now, because marijuana is legal and because medical marijuana is becoming more common as a treatment for a medical condition that could be classified as a disability, is, do you have to provide an accommodation to folks that take marijuana? And so under the ADA and now under the Virginia Human Rights Act that we just talked about, it would violate those statutes to discriminate on the basis of a disability. So someone that tells you, I want a job here, I take medical marijuana, and you say you're not getting hired, because of that, they would likely have a claim. Employers have to provide a reasonable accommodation. And so the term medical impairment does not include alcoholism or drug addiction. So it's different to say, I'm just going to partake in alcohol or use marijuana than it is to say, I need medical marijuana as a treatment for a disability. So those two things, you know, when you go through your processes for an accommodation, you likely have a written form where the request is made and potentially additional medical information required of a physician. You should keep good records of that. You should analyze that carefully. You should make sure you follow those processes so that you are making the folks that need the benefit step through the hoops just as anybody else that need an accommodation, to kind of pare down on anybody that wants to take advantage of the process. So it's, again, not an easy issue. One example would be that the employee is prescribed marijuana for disability, requests a reasonable accommodation. 2 weeks later, the employee tests positive under a random test. Can you discipline them under your policy? If they have the accommodation, and the accommodation may be, I'm going to use marijuana not at work. I'm going to use marijuana at home for pain relief, for sleep aid. I don't know all the reasons that someone would prescribe it. I'll use it for that. And so the testing might be the accommodation. Okay, we know you're going to test positive. You won't be disciplined for that. But if the employee is under the influence at work, that's not an accommodation you have to provide, particularly if they are in a safety role. So, you know, getting some help on these issues that are very difficult to work through is probably a good idea. One other point just to make on marijuana, and I know we're running out of time, is you can't ask for a disclosure of those convictions anymore in Virginia. So if you've got criminal conviction, you might want to edit that part of your application. So just a quick note on Virginia's Fraud, Abuse, Whistleblower Protection Act. Everybody's worried about whistleblowers. This became effective July 2020. There's a 1-year statute of limitations. These are the damages. The important thing to note is what a whistleblower is protected for. Not every complaint is protected under a Whistleblower Protection Act. So it's in Virginia, it's very limited. And so the limited protected activities are reports of a violation of federal or state law, participation in an investigation, hearing, or inquiry, refusal to engage in a criminal act, refusal to perform an act that violates federal or state law, and provides information or testifies before a government body. So, you know, somebody complaining, you know, that they don't like what their boss is doing is not necessarily protected under this statute. So if anybody, I would train your managers to listen for these kinds of complaints, but go back with HR and review these particular provisions. And if they fall under these provisions, you probably need to get some guidance about, okay, how do we deal with the conduct issue they already have? Because we know these things come up when they're getting ready to be terminated, they're getting ready to be written up for the last time, and somebody suddenly has a complaint, whether it's a discrimination complaint or a whistleblower complaint. So these are the tips. Many of them are what we've recommended in other circumstances. Make sure you've got your handbook updated to reflect this. And again, this is just general advice that we've always been following. Have a good provision in your handbook that talks about what is acceptable conduct, what is not acceptable conduct. Have your employees acknowledge that, and make sure you document when employees' conduct does not fit the bill. And then that fits into the record of legitimate, non-discriminatory, non-retaliatory reasons for the conduct. So I've got 2 minutes. I'm just gonna touch on these worker misclassification. So the issue of whether an employee or independent contractor is properly classified has always been a big issue. Virginia has now a statute that talks about it. The big key here is if you have independent contractors and they should be employees, those folks can now bring a lawsuit against the company. And so what they're going to sue you for would be overtime. They're going to sue you for workers' comp, unemployment, benefits, vacation time, taxes. So if they've been paying their own taxes and they're not classified correctly, those are all the things you're going to want back in that lawsuit, and they're also entitled to their attorney's fees. And then one last quick point is the new statute on prohibiting non-competes for low-wage earners. So if you have executives and they have a non-compete and they make more than that number right there, $62,140,000, perfectly fine. If you have low-wage earners, people that make less than that money, we cannot subject them to a non-compete. And so if they've entered into one in the past, so long as you don't enforce it or threaten to enforce it, you're fine. You can certainly have a confidentiality provision with anybody making any amount of money. There is a bit of a question about whether this prohibition applies to non-solicitation provisions. So if you have somebody that makes less than that 62,140, we think the law will develop to say that they can have a non-solicitation provision that says you cannot directly solicit the customer, but not one of those provisions that says hire, accept calls from, encourage to leave, any of that. So the remedies include all of these items. So make sure you review your non-competes and update those. You're probably already doing that. And most importantly, before you send out that form cease and desist letter to, maybe you're not even going to sue them, but you want to scare them out of it, don't do that until you review that issue and make sure that that is an enforceable provision. So it's 12 o'clock. I saw no questions. I'm sorry I went through that so quickly. We had a lot to cover in Virginia over these last couple of years.
But Betsy, thank you. I mean, that was extremely thorough, the PowerPoint presentation. So I will send that out to everybody afterward when I get it from Betsy. Thank you so much. This was quite informative. Appreciate all the diligent work you did on putting this together for our members. And I will send the, let's see, I will send out the PowerPoint and the link to everybody to the recording as well. So you can review it again. And if you have any questions that Betsy said, contact them or Whiteford Taylor or, your own attorneys. That would be good. So yes, thank you.
Thank you for being with me.